Hello, dear students. Welcome to the new session of the business regulations and especially the Indian Contract Act. So, in the last classes, we were discussing the different essentials of the creation of an valid contract. The last chapter, we have discussed the offer and acceptance. What is an offer? What is an acceptance? How an offer and acceptance is equally important to create a valid contract. Also, we have discussed, and how we can end to how we can revoke a contract in terms of an offer and acceptance. Also, we have discussed in the last session. So in this session, we are going to discuss the second important essentials of a contract, that is consideration. We have in the first chapter discussed a valid consideration is important to create a contract. We have discussed already. So we'll deeply discuss how consideration is important and what is consideration and what else can constitute a consideration and how the consideration should be shared among the contractual parties that we will discuss in this chapter. So first of all, we will discuss what is a consideration is all about. In the section 2D of the Indian Contract Act defines consideration as when at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something such as or abstinence or promise is called consideration for the promise. It is a very comprehensive and detailed definition regarding the consideration. We'll go through each line and discuss what is the definition is all about. When at the desire of the promisor, the consideration is comes from the desire of the promisor, and the promisee is giving back the consideration, and the consideration may be doing something or abstaining from doing something. That means he may not doing something as a part of the contract. That means he is not trying to do something, he is abstaining from doing something. That is that may be or that is called known as a consideration is all about. So we'll discuss the each point. The term consideration is used in the sense of quid pro quo. That means something in return, which is used in a Latin term. I want something, you want something. That is the concept of consideration. You will give me what I want, I will give you what you want. That is the simple concept of consideration. So both the contractual parties must have received something as a part of contract. That is the essence of consideration is all about. I want something, you want something. You will give me what I want, I will give you what you want. So both parties will have a role in that. The most commonly accepted definition of consideration is given in the famous English case, that is Curie versus Missa. Some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other is a part of consideration, we can say. So it's not just what we see, the benefits one who receives, and the another part is that even if somebody is not receiving any positive benefit, that is also considered to be a consideration that we will discuss in detail. The essentials of a valid consideration. Every point will have a essentials. We will discuss that in detail in this session. The first one, it must move at the desire of the promisor. In the definition itself, the first point was that itself, the act or the abstinence must have been done at the desire of the promisor. Any act performed at the desire of the third party cannot be consideration. It will not form into a consideration. That means promisor is the person who is deciding what is the consideration is all about. And the act of an act of doing something or act of abstaining from something, that must be suggested by the promisor itself. That is the essential essence of a consideration is all about, that we will discuss in detail. And the second one, it must move from the promisee or any other person. As long as there is a consideration for a promise, it is immaterial who has given it. It may move from the promisee, or if the promiser has no objection, from any other person. That means if I want a TV, that the promiser is suggesting that, and the payment is to be given by the purchaser or the customer of that TV or the television. So the what is the act happening there? The act is delivering a TV, and who is giving the money? That is not a consideration for the promiser. Anybody can give the money. If I am purchasing a TV, I can pay for it, or some other person can pay for me. That is not the consideration, or that is not the concern of the seller. So that is a case here. Anybody can, that the promise or the consideration can move from anybody. That is not a consideration for, that is not a problem for the uh, what we call the promisor. So consideration can be moved from a third party also. And next one, it need not to be adequate. Inadequacy of the consideration is no ground for refusing the performance of the promisee unless it is evidence of proof. That means if we have agreed upon the consideration, that means this is the consideration as a part of this contract. If we have already discussed and finalized it, then there is no point in saying that this consideration is inadequate. That means maybe at the point of, if you are purchasing a gold, today we have booked a gold, what we call maybe a 10 pound or 20 units we have purchased or booked, not purchased, booked. But we are booked that gold at the present market value, and the purchaser or the customer is always having the right to get that product or gold at the rate at which he has already booked. Maybe in the next day or in the next week, the market price of the gold may increase, but the seller cannot say that this price cannot be, this price is inadequate and we cannot perform the contract. That is not possible because already they have entered into a contract for a particular rate. So inadequacy is not a point of refusing a contract of performance. Even though the price is inadequate, as part of the contract we have already entered, we are supposed to go ahead with the consideration that already being agreed upon in the contract. The later stage, we cannot say that this consideration is inadequate. And it may be past, present, or future. Consideration is having three types. One is past consideration. When the consideration for a present promise was given before the date of promise, it is said to be past consideration. That means we have already given the consideration before performing the before performing the obligation from one party. So that is a past consideration is all about. And the present consideration, when the consideration for a promise is given simultaneously with the promise, it is called present consideration. That means if one party is performing his obligation, at the same time the other party is performing his obligation. That means if I purchase a TV or any other product, and the seller is delivering the product to me, and at the same time I'm giving back the amount or the consideration to him itself at the same time, that is simultaneously, that is called present consideration. And the third one is future consideration. A future or executory consideration is a promise to do or give something in return in future for the promise then made. It means even if the obligation one from one party is executed, the other party is not executed. That is, maybe we can see some kind of a sales strategy called installment system. So we may not paying the entire amount of consideration to the seller at the time of purchase. We may be paying that amount in installments, or maybe we may have paid the down payment and the installment amounts in the future. Maybe in some cases, like in credit cards and all, we need not to pay any down payment. We can entirely purchase the product without any cost, and we have to pay the EMIs in the future. So that kind of a consideration is called future consideration. So this is something which is in related to the mechanism of giving the consideration. It's not just the different classifications we can say, but it is how we deliver the consideration. On that basis we can divide this consideration into three. And consideration must be a real one. There should not be any illusionary product as a consideration. Consideration must be real and not illusory. It must be competent. If it is physically impossible, vague, or legally impossible, the contract cannot be enforced. That means we have to give a real product, or actual money as consideration. We should not give anything illusory. It must be competent. It must be competent in the sense it must be adequately valued for the product which is being exchanged. And if it is not physically possible, that means we have already said that contract must be physically possible to be performed. If the contractual party is giving consideration something which is physically impossible, that will not be considered as consideration. And the vague or illegal products should not be given or exchanged between the contractual parties. Then the consideration is not real, we can say. And next one is consideration must be a lawful one. An agreement is void if it is based on unlawful object. An agreement is considered unlawful if it is forbidden by law, is of a nature that is permitted, it will defeat the provisions of any law, is fraudulent, is involved or implies injury to the person or property of another. The court regards it as an immoral or opposed to the public policy or the property. So we have already discussed what is a illegal agreement or a consideration is all about. So this kind of illegal things should not be given as a consideration in a lawful agreement. It should not be forbidden by the consideration, should not be forbidden by law. It means if you are giving back a black money, that is not a part of that is forbidden by law already. Or if we are giving any poisonous products or any kind of an drugs as a part of the consideration, that is not legal. And anything which is against the law and which is fraudulent, and anything which involves, implies or injury to another person is not a consideration. And something which is against the society is also not lawful. So these are not legal, we can say. So the legal consideration must be exchanged. So it must be something which the promisor is not already bound to do. If something already he is supposed to do, it is not a consideration, we can say. If he is in case of an government office, if the government officer is supposed to do a duty, it is his duty. He is not supposed to get any bribe as a part of his duty, because it's duty already. So we'll discuss this next points in next class. I think I